Hi, I'm Jeffrey Islander from Schlamm, Stone & Dolan, and today I want to talk about a situation that many practitioners encounter in business litigation, and that is a fraudulent inducement claim in connection with the purchase of assets. A problem that many litigants encounter are disclaimers in the sales contracts which disavow any representations that were made to the buyer. Over 60 years ago, in Dannon, D-A-N-N-A-N, the New York Court of Appeals held that if a merger clause disclaims reliance on specific representations, that disclaimer could bar a fraud claim. In other words, if you were a purchaser and you were relying on verbal representations as to some characteristic of the asset that you were buying, those very representations were disclaimed in the sales contract, you were out of luck in suing for fraudulent inducement. But in the past few years, the courts have been very inconsistent in following that rule. In one case, an appellate division said that a disclaimer that merely referenced prior discussions of the subject matter was a sufficient disclaimer of such parole evidence. Another appellate division case also said that references to the subject matter of the agreement was a sufficient disclaimer. Other cases, however, have rejected general disclaimers and have insisted on more specific language. So as a practice pointer, this is what I would suggest. If you are representing a buyer, I would insist on general disclaimers and very specific representations and warranties, because you can always sue to enforce a representation warranty as long as it's in effect. And if there's specific representations and warranties in the agreement, you will not have to rely on parole evidence. In contrast, if you're representing a seller, I would insist that the merger clause be very specific in the representations that it is disclaiming, and that there be limited representations and warranties.